Consent and capacity. Ethical principles underlying consent and capacity. Consent is the autonomous authorization of a medical intervention by a patient. Usually, the principle of respect for patient autonomy must be balanced with the principle of beneficence, since a physician need not offer an intervention that does not serve some benefit based on their clinical judgment. Informed consent is a process, not a transaction or a signature on a page. Informed refusal is equivalent in principle and approach. If a patient is deemed incapable of consenting to a proposed medical intervention, then it is the duty of the SDM or the physician in an emergency to act on the patient's known prior wishes, or failing that, to act in the patient's best interests. Let's see, SDM, I'm not so sure. Substitute decision maker. Urgency to act. It's the duty of the SDM to act on the patient's known prior wishes, or failing that, to act in the patient's best interests. There is a duty to discover, if possible, what the patient would have wanted when capable. Central to determining best interests is understanding and taking into account the patient's values, beliefs, and preferences, including any relevant cultural and/or religious considerations and the patient's interpretation of those considerations. More recently, expressed wishes take priority over remote ones. Patient wishes may be expressed verbally or in written form. Patients found incapable of making specific decision should still be involved in the decision-making process as much as possible. If a patient found incapable expresses a willingness to pursue the proposed treatment intervention, then this is known as assent rather than consent, which requires capacity. Agreement or disagreement with medical advice does not determine findings of capacity or incapacity. However, patients opting for care that puts them at risk of serious harm that most people would want to avoid should have their capacity carefully assessed. Steer clear from the tendency to define what reasonable person standards may be. If appropriate, look to discern patterns of justification offered by patients and their individual values and beliefs, which may be influenced by social context, such as culture and or religion. Laws pertaining to consent and capacity may vary by province territory, and readers are encouraged to consult provincial territorial guidelines. CPSO policy consent. Obtaining valid consent before carrying out medical, therapeutic, and diagnostic procedures has long been recognized as an elementary step in fulfilling the physician's obligations to the patient. PSO policy on capacity. Capacity is an essential component of valid consent, and obtaining valid consent is a policy of the CMA and other professional bodies. Four basic requirements of valid consent. We have here voluntary, capable, specific, informed. 1. Voluntary. Consent must be given free of coercion or pressure, for example, from family members who might exert undue influence from members of the clinical team. The physician must not deliberately mislead the patient about the proposed treatment. The physician must engage in self-reflection prior to entering the conversation regarding their position of power and privilege, as well as take measures to mitigate the power differential within the relationship. 2. Capable. The patient must be able to understand and appreciate the nature and effect of their condition as well as of the proposed treatment or decision. Specific. The consent provided is specific to the procedure being proposed and to the provider who will carry out the procedure. For example, the patient must be informed if students will be involved in providing the treatment. Informed. Sufficient information and time must be provided to allow the patient to make choices in accordance with their wishes, including the nature of the treatment or investigation proposed and its expected effects, all significant risks and special or unusual risks, disclose common adverse events and all serious risks, for example, death, even if remote, alternative treatments or investigations and their anticipated effects and significant risks, the consequences of declining treatment, answers to any questions the patient may have. The reasonable person test. The physician must provide all information that would be needed by a reasonable person in the patient's position to be able to make a decision. It is the physician's responsibility to make reasonable attempts to ensure that the patient understands the information, including overcoming language barriers or communication challenges. Physicians have a duty to inform the patient of all legitimate therapeutic options and must not withhold information based on conscientious objections, for example, not discussing the option of emergency contraception. Okay, blue box. Professional considerations. Geriatric patient. Identify their goals of care and resuscitation options, CPR or DNR. Note, we should aim to have goals of care discussions with all patients, regardless of age. Check for documentation of advanced care planning, commonly referred to as advanced directives, and POA where applicable. Pediatric patient. Identify the primary decision maker, if applicable. Parents, guardian, wards of state, emancipated. Regarding capacity assessment, see pediatric aspects of capacity. Be aware of custody issues, if applicable. Terminally ill or palliative patient. Consider the spikes approach to breaking bad news. We'll see in Elom 16. Identify the patient's goals of care, that is, disease versus symptom management. Identify whether an advanced care plan exists. We'll see palliative care, palliative medicine. Determining the patient's SDM according to the SDM hierarchy. If the patient has a POA that obtain a copy of the document, then obtain a copy of the document. Check for documentation of resuscitation options, CPR or DNR. Incapable patient. Note, capacity is treatment specific and time specific. An incapable patient is only incapable for the specific treatment at the specific time. If not already present, perform a formal capacity assessment and thoroughly document. Identify if the patient has an SDM or who has their POA and locate it, if applicable. Check the patient's chart for any mental health forms, for example, Form 1, or any forms they may have on their person, for example, Form 42. I just want to check POA. Power of attorney. Flowchart. Ontario Consent Flowchart. Adapted by Herbert P. from Sunnybrook Health Science Center Consent Guidelines. Is this a treatment? No. Use common law. Is this treatment? Yes. Is the patient capable to make this decision? Let's follow the yes pathway first. Yes. Does the patient consent? Yes. Treat. Does the patient consent? No. Do not treat. Is the patient capable to make this decision? No, he is not. Is this an emergency? If yes, is there a SDM available? Substitute decision maker available? No. Treat as emergency following any known prior capable wishes, for example, Jehovah Witness card. If there is an SDM available, is the SDM capable to make this decision? If no, the same, you go to treat the emergency following any prior capable wishes. If the SDM is capable to make the decision, does the SDM consent? Yes, treat. No, do not treat. If this is not an emergency, discuss involvement of SDM. Does patient dispute the finding of incapacity? Yes, review board. No. Does the SDM consent? Yes or no? If there is no SDM for the incapable patient, the doctor can apply to the CCB to appoint a patient representative. CCB, Consent and Capacity Board. If the doctor has good reason to think the SDM is making inappropriate decisions for the incapable patient, an application can be made to the CCB to review the SDM's decisions and appoint a new patient representative. Obtaining legal consent. Consent of the patient must be obtained before any medical intervention is provided. Consent can be verbal or written, although written is usually preferred. A signed consent form is only evidence of consent. It does not replace the process for obtaining valid consent. Most important component is what the patient understands and appreciates, not what the signed consent form states. Implied, for example, a patient holding out their arm for an immunization, or expressed. Consent is an ongoing process and can be withdrawn or changed after it's given, unless stopping a procedure would put the patient at risk of serious harm, and the patient is not informed of and or capable of considering these harms. If consent has been withdrawn during a procedure, the physician must stop treatment unless stopping the procedure would threaten the patient's life. In obtaining consent to continue the procedure, the physician need only re-explain the procedure and risks if there has been a material change in circumstances since obtaining consent originally. If there has been no material change in circumstances, simple assent to continue is sufficient. Charlariello v. Charter. HCCA of Ontario, 1996, covers consent to treatment, admission to a facility, and personal assistance services, for example, home care. Exceptions to consent. 1. Emergencies. Treatment can be provided without consent where a patient is experiencing severe suffering or where a delay in treatment would lead to serious harm or death and consent cannot be obtained from the patient or their SDM. Emergency treatment should not violate expressed wish of the patient, for example, a signed Jehovah's Witness card. If patient is incapable, the physician must document reasons for incapacity and why situation is emergent. Patients have a right to challenge a finding of incapacity as it removes their decision-making ability. If a SDM is not available, the physician can treat without consent until the SDM is available or the situation is no longer emergent. 2. Legislation. Mental health legislation allows for the detention of patients without their consent. Psychiatric outpatients may be required to adhere to a care plan in accordance with community treatment orders. Public health legislation allows medical officers of health to detain, examine, and treat patients without their consent. For example, a patient with TB refusing to take medication to prevent transmission of communicable diseases. 3. Special situations. Public health emergencies, for example, an epidemic or communicable disease treatment, warrant for information by police. Consequences of failure to obtain valid consent. Treatment without consent is battery, a claim in tort, meaning a civil legal matter, as opposed to a criminal legal matter, even if the treatment is life-saving, excluding situations outlined in exceptions to consent. Treatment of a patient on the basis of poorly informed consent may constitute negligence, also a claim in tort. The onus of proof that valid consent was not obtained rests with the plaintiff, usually the patient. Overview of capacity. Capacity is the ability to understand information relevant to a treatment decision, appreciate the reasonably foreseeable consequences of a decision or lack of a decision. Capacity is specific for each decision. For example, a person may be capable to consent to having a CXR but not for a bronchoscopy. Capacity can change over time. For example, temporary incapacity secondary to delirium. Most Canadian jurisdictions distinguish capacity to make healthcare decisions from capacity to make financial decisions. A patient may be deemed capable of one but not the other. A person is presumed capable unless there is good evidence to the contrary. Capable patients are entitled to make their own decisions. Capable patients can refuse treatment even if it leads to serious harm or death. However, decisions that put patients at risk of serious harm or death require careful scrutiny. Assessment of capacity. Capacity assessments must be conducted by the clinician providing treatment and, if appropriate, in consultation with other healthcare professionals. For example, another physician, a mental health nurse. Clinical capacity assessment may include specific capacity assessment, that is, capacity specific to the decision at hand. 1. Effective disclosure of information and evaluation of patient's reason for decision. 2. Undergoing of the condition, the nature of the proposed treatment, alternatives to the treatment, the consequences of accepting and rejecting the treatment, the risks and benefits of the various options. And 3. For depreciation needed for decision-making capacity, a person must acknowledge the symptoms that affect them, be able to assess how the various options would affect them, be able to reach a decision and make a choice not based primarily upon delusional belief. General impressions. Input from psychiatrists, neurologists, etc., for any underlying mental health or neurological condition that may affect insight or decision making. Another way of doing the clinical capacity assessment. Employ aid to capacity evaluation or any other capacity assessment tool guideline. Another way, a decision of incapacity may warrant further assessment by psychiatrists, legal review boards, for example, in Ontario, the Consent and Capacity Review Board, CCB, or the courts. The patient has the right to a hearing before the CCB. If found incapable by the Consent and Capacity Review Board, patient must receive notice of their ability to pursue judicial review and essentially appeal the determination. Capacity assessment criteria in Ontario. Test for understanding. Can the patient recite what you have disclosed to them in their own words? Test for appreciation. Are their beliefs responsive to evidence? Refer to JAMA, the rational clinical examination. Does this patient have medical decision-making capacity? Box 2. Aid to capacity evaluation. Ability to understand the medical problem, ability to understand the proposed treatment, ability to understand the alternatives, if any, to the proposed treatment, ability to understand the option of refusing treatment or of it being withheld or withdrawn, ability to appreciate the reasonably foreseeable consequences of accepting the proposed treatment, ability to appreciate the reasonably foreseeable consequences of refusing the proposed treatment, and ability to make a decision that is not substantially based on delusions or depression. Treatment of the incapable patient in a non-emergent situation. Obtain informed consent from SDM. An incapable patient can only be detained against their will to receive treatment if they meet criteria for certification under the Mental Health Act. In such a situation, document assessment in short, notify patient of assessment using appropriate mental health forms under the Mental Health Act, Form 42 in Ontario, notify rights advisor. Substitute decision makers. SDMs must adhere to the following principles when giving informed consent. Act in accordance with any previously expressed wishes that were expressed when capable. If wishes are unknown, act in the patient's best interest, taking the following into account. 1. Values and beliefs held by the patient while capable. 2. Whether well-being is likely to improve with versus without treatment. 3. Whether the expected benefits outweighs the risk of harm. And 4. Whether a less intrusive treatment would be as beneficial as the one proposed. The final decision of the SDM may and should be challenged by the physician if the physician believes the SDM is not abiding by the above principles. Instructional advanced care planning. Allow patients to exert control over their care once they are no longer capable. The patient communicates their decisions about future health care, including who they would allow to make treatment decisions on their behalf and what types of interventions they would not want. To be used once the patient is incapable with respect to treatment decisions. In Ontario, a person can appoint a power of attorney for personal care to carry out their advance directives. The legal threshold to appoint a power of attorney for personal care is intentionally set lower than the legal threshold for capacity to consent to many complex medical treatments. This allows a patient that lacks treatment capacity to appoint a person of their choosing to make the decision for them. Patients should be encouraged to review these documents with their family and physicians and to reevaluate them often to ensure they reflect their current wishes. Powers of attorney. All guardians and attorneys have fiduciary duties for the dependent person. Definitions. Power of attorney for personal care. A legal document in which one person gives another the authority to make personal care decisions, healthcare, nutrition, shelter, clothing, hygiene, and safety, on their behalf if they become mentally incapable. Guardian of the person, someone who is appointed by the court to make decisions on behalf of an incapable person in some or all areas of personal care, in the absence of a POA for personal care. Continuing power of attorney for property. Legal document in which a person gives another the legal authority to make decisions about their finances if they become unable to make those decisions. Guardian of property. Someone who is appointed by the public guardian and trustee or the courts to look after an incapable person's property or finances. Public guardian of trustee and trustee acts as a SDM of last resort on behalf of mentally incapable people who do not have another individual to act on their behalf. Pediatric aspects of capacity covered. No age of consent in all provinces and territories except Quebec. Consent depends on patients' decision-making capacity. Quebec has a specific age of consent, but common law and case law deem underage legal minors capable, allowing these individuals to make their own choices. Infants and children are assumed to lack mature decision-making capacity for consent, but they should still be involved in decision-making processes when appropriate. That is, be provided with information appropriate to their comprehensive level. Adolescents are usually treated as adults. Preferably, assent should still be obtained from patient, even if not capable of giving consent. In the event that the physician believes the SDM is not acting in the child's best interests, an appeal must be made to the local child welfare authorities. Under normal circumstances, parents have right of access to the child's medical record. Blue box. Most provinces have legislated hierarchies for SDMs. The hierarchy in Ontario is legally appointed guardian, appointed attorney for personal care if a power of attorney confers authority for treatment consent, representative appointed by the consent and capacity board, spouse or common law partner, child age 16 or older, or parent unless the parent has only a right of access. Parent with only a right of access, sibling, other relatives, public guardian, and trustee. Other types of capacity not covered by the HCCA. Testamentary, ability to make a will, fitness, ability to stand trial, financial, ability to manage property, Form 21 of the Mental Health Act, personal, ability to care for oneself on a daily basis, and substitute consent for a procedure whose primary purpose is research, sterilization for non-therapeutic purposes, or removal of organs or tissue for transplantation does not apply to those already declared dead. There is no age of consent in Ontario. Capacity is assessed on an individual basis. Okay. Next video we'll talk about negligence.